participants, it is an honor and a pleasure to be here today. Many thanks to Professors Schweitzer and Frank for the invitation. Many thanks to Professor Wambach for hosting us here at the ZEW. I hope that I'm not going to disappoint after that nice introduction, because right now I'm more an observer than a practitioner of competition law. My previous role as Director General of DG Competition in the European Commission has already been mentioned. That means that I bore systemic responsibility for many of the cases scrutinized over the last years and still being scrutinized at the EU courts. And naturally, therefore, I have not handled competition cases since my appointment as judge at the General Court 3 years ago. And by extension, I feel also bound to exercise restraint when commenting on individual cases. But nevertheless, I do hope that the two perspectives that I bring to today's debate on the future of Regulation 1, the one of an enforcer and the one of a judge, allows me to make a useful contribution to the more fundamental aspects of the debate. I think that both perspectives share a similar interest in the relevance, in the quality, and the speed of competition enforcement. Upfront, before going more into detail, I would also like to thank my legal secretary, James Kröger, for the co-authorship of this intervention, and my colleagues at the General Court, President Mark van der Woude, President of Chamber Anna Marcoli, and Judge Susanne Kingston for helpful input and observations. Earlier this year, the European Commission took the initiative to evaluate the EU's antitrust procedures following changes to the economic landscape, e.g. digitization, since Regulation 1/2003 entered into force. That is 2 decades ago. The feedback and consultation period scheduled by the Commission has just closed. Obviously, my remarks should not be read as a formal contribution to this exercise. They are just food of thought for today's conference. Regulation 1/2003 itself was adopted with a view to ensuring a more efficient enforcement of competition rules. The shift from a system of individual notification to a system of direct applicability of then Article 81, now Article 101 of the treaty, has released important resources, brought the European competition network into being, and focused competition enforcement on priorities grounded in a more economic approach. It is not an exaggeration to term the 2 decades since the inception of the regulation a success story. I will not expand very much on this because Wouter Wils's contribution that you have received in writing, I think, details that in a quite admirable way. But one should never take success for granted. As suggested by the Commission initiatives, the times remain a-changing, to paraphrase the singer-songwriter whose career has been crowned by a Nobel Prize and who started the career at the time when the predecessor of Regulation 1/2003, namely Regulation 1762, was first enacted. In fact, digitization is only one factor of change and acceleration of change, but maybe the most illustrative one. When Regulation 1 came into force, the time was ripe for a more economic, as in less form-based, and thus at the time undoubtedly more efficient approach to enforcement. Instead of spending its resources on comfort letters for standard agreements between businesses, the Commission could henceforth direct them at hardcore infringements of competition rules, and this allowed in particular for a long and substantial string of cartel prosecution. These cases frequently demanded extensive investigations and require time-consuming and resource-intensive judicial review, and a number of these cases even gave rise to successful actions for damages against the Court of Justice due to the excessive duration of the procedure before what was originally the Court of First Instance and is today the General Court. This was one of the reasons for the reform of the General Court, and in particular the doubling of the number of its judges. It may be too early for a comprehensive assessment of this reform concluded in 2019, but the more recent experience suggests that it has had an overall positive impact. But crucially, whilst these cases raised significant substantive and procedural issues, their economic rationale was essentially uncontested. However, roughly 10 years after Regulation 1 had been prepared, the discussion around the so-called Commission priorities paper showed that there was no similar degree of common ground regarding the economic rationale for enforcement under Article 102 TFEU. And when the focus shifted further towards the enforcement of the union's competition law in the rapidly evolving digital economy, the economic assessment of what constitutes competition on the merits and what constitutes anti-competitive behavior became even more contentious. Not all cases have had a history as long, as intricate as the Intel case and its core issue of the assessment of fidelity rebates by dominant undertakings. But the fact that such a case could span over 2 decades since the original complaint without yet having come to a definitive conclusion shows that not all areas of competition enforcement have met the standard of efficiency sought when Regulation 1 was first enacted. And justice delayed is justice denied, as the saying goes. Already in 2020, the European Court of Auditors pointed to investigations that were generally lengthy and which might negatively affect the effectiveness of decisions. More precisely, as Heinemann has put it, excessively long procedures prevent the swift restoration of competition and impair the deterrent effect of sanction. Therefore, the question of the impact and workability of the enforcement framework has not gone away. Heinemann rightly continues to point out that the design of substantive and procedural law can also be responsible for lengthy procedures. Make no mistake, complex questions like those raised by Intel and a number of other cases will always require thorough administrative investigation and judicial review, and that will take time. Complexity, as was mentioned last night, cannot be wished away. However, it is still the task of an efficient legal framework to adjudicate complex cases in a useful time span conducive to legal certainty, despite complexities or even uncertainties. Hence, the reflection on how to pave the way towards an even more efficient approach. It is, of course, impossible to exhaust this subject in the few minutes allocated for my remarks, which is why I have chosen to mention just a few aspects among the many aspects that one might wish to consider. And choosing a few aspects, of course, at the expense of others carries the risk of imbalance. But a useful debate depends also what we in German call the Mut zur Lücke, and it will be for others then to muster the courage to close the many gaps that my remarks will leave. And indeed, that has started already yesterday with the different panels that we saw. The recent case practice and law under Article 102 has raised particular attention when it comes to the workability and enforceability of competition law. Let me therefore mention 3 emblematic cases decided by the General Court earlier this year as a starting point and take the reflection from there. Firstly, following the 2017 judgment of the Court of Justice on appeal against the original judgment of the General Court rendered in 2014, the General Court held in its Intel renvoi judgment that the Commission failed in providing a complete analysis of the anti-competitive effects of the fidelity rebates under assessment. This was due to perceived deficiencies in the as efficient competitor test conducted complementarily to the qualitative assessment of these rebates. The Commission has lodged another appeal against this judgment. Secondly, in the so-called Qualcomm exclusivity payments judgment, the General Court annulled the Commission decision due to violations of Qualcomm's rights of defense. It also found shortcomings in the Commission's assessment of the foreclosure effects of exclusivity payments. Differently from Intel renvoi, the Commission decided not to lodge an appeal against this judgment. Finally, in its Google Android judgment, the General Court largely confirmed the Commission's decision, fining Google for imposing anti-competitive contractual restrictions on manufacturers of mobile devices and mobile network operators, even though, in its view, the AEC test conducted by the Commission did not support certain findings in relation to the investigated revenue share agreements. Whilst being, of course, different from each other in tel renvoi, Qualcomm exclusivity payments and Google Android seem to give credit to the impression that in complex cases, the judicial review puts a very heavy burden on enforcement. And as recently stated by Castillo de la Torre, such cases tend to objectively imply more complex investigations, critically many more resources, with the consequence that other cases inevitably end up not being investigated. This begs the question of whether challenges to the effectiveness and efficiency of competition enforcement stem primarily from evolving standards of judicial review of complex assessments and more specifically complex economic assessments, and whether the solution to such challenges would lie in greater judicial restraint. In a system like the one instituted by the TFEU, that is based on administrative decision-making and subsequent possibility of judicial review, the division of labor between the administration and the judiciary is a decisive factor for the effectiveness and the efficiency of competition enforcement. The degree of judicial review of complex assessments, and more specifically of scientific assessments, including economic assessments, is at the heart of the matter. The starting point for the answer to this question is the TFEU itself. The treaties do not conceive the Commission as a partisan prosecutor, but as an independent regulator equipped with the necessary expertise to take impartial decisions subject to further checks and balances through the Union courts. Regarding competition enforcement, both the treaties and Regulation 1 differentiate between the standard of judicial review of fines, that is unlimited, and the general standard of judicial review. For quite some time, the general standard of review was termed to be, in inverted commas, a marginal standard of review. The word marginal suggested a broad and for many undue discretionary margin of the administrative authority. A long-standing criticism considered that this led to a jurisprudence that was allegedly too deferential to the Commission. A prominent voice of this criticism is my former colleague at the General Court, Ian Forrester. He repeatedly shared the view that, I quote, a standard of review of manifest error and legality would undermine the legitimacy of the enforcement of the competition rules by the Commission. However, already in 2011, the then president of the General Court, Mark Jäger, asked the question whether the standard of review in competition cases involving complex economic assessments had shifted towards the marginalization of the marginal review standard. His answer drew on the substance behind the words. According to the Court of Justice in its Constant and Rundig judgment, the Union courts need to take into account the very nature of the complex economic evaluation conducted by the Commission by confining the judicial review to an examination of the relevance of the facts and of the legal consequences which the Commission deduces therefore. In the Remia judgment, the role of the Union courts was defined as verifying whether the relevant procedural rules have been complied with, whether the statement of reasons for the decision is adequate, whether the facts have been accurately stated, and whether there has been any manifest error of appraisal or misuse of power. So at the time, Mark Jäger answered the question in concluding that the General Court standard of review is respectful of the institutional balance, but intense in relation to complex economic studies, calculations, and data in general. Marginal review is thus limited to policy choices based on complex economic assessments. A little bit later, in 2013, following the Menarini judgment of the European Court of Human Rights, the Court of Justice stressed in the Kone judgment that a decision by an administrative authority imposing a penalty needs to be examined in all respects on questions of fact and law. This means that the Union courts have to consider the arguments and all the relevant elements put forward by the parties. Complexity does not dispense from an in-depth review of the law and of the facts. In my view, this is the essence of the general standard of judicial review. where the administration carries out complex assessments, whether scientific, technical, or economic, the union courts do not substitute their own scientific, technical, or economic assessment for the one of the administration, but they verify whether the way the administration reached its conclusion is legally justified. Now, are the most recent developments in the case law just mentioned the expression of an even more intense judicial review standard in relation to complex assessments and in particular complex economic assessments? When discussing this question, one should not lose sight of the fact that under the treaty, judges are not selected because of their economic expertise. The so-called 255 committee after Article 255 of the treaty gives an opinion on the candidate's legal expertise to perform the duties of judge of the union courts. It may happen that individual judges bring such expertise, economic expertise, due to biographical accident or lifelong learning, or even by attending what one terms so-called economic boot camps. But under the rule of law, a system of judicial review cannot and should not rely on the degree of ultimately accidental education of judges on matters of science, technology, or economics. The degree of expertise required from judges and the consequent degree of intensity of the review that they perform needs to be set by the system itself according to objective and verifiable standards. To put it with Potsun, the material provisions of anti-competitive conduct need to remain in the grip of normativity. That is, they need to be accessible to legally trained judges with a good economic understanding, the good economic understanding being between brackets. Unsurprisingly, and against this background, I do not read the recent judgments as a decisive departure from the standard of general judicial review as developed and refined by the jurisprudence over time. In my view, the Intel Renvoi, Qualcomm exclusivity payments, and Google Android judgments rather reflect the tendency that judicial review has become increasingly process-oriented. And in this respect, the influence of the enshrinement of the EU's Charter of Fundamental Rights has undoubtedly sharpened the sensibility for procedural rights, in particular the rights of defense in judicial proceedings during the time of Regulation 1's existence. As Potsun suggested, a closer look reveals that the Intel 2017 Court of Justice judgment is a judgment on procedure, not on substance. This understanding appears reinforced by other recent judgments centered on the rights of defense of the investigated undertakings, and in particular judgments dealing with specific investigative steps. In the Nexans judgment, the Court of Justice found that the Commission has the right to continue the inspection of data at its Brussels premises on the basis of a copy where it can legitimately take the view that it is justified in doing so in the interests of the effectiveness of the inspection and to avoid excessive interference in the operations of the undertaking concerned. But the court stressed that such inspection must be in strict compliance with the rights of defense. In his orders in Facebook Ireland versus the Commission of the 21st of December of last year, the President of the General Court held that a level of protection similar to that guaranteed by Article 20 of Regulation 1 in relation to inspections should apply to requests for information and provided an ad hoc safeguard mechanism for the examination of documents likely to contain sensitive personal data. And more broadly, this is also underscored by judgments that reinforce the rights of complainants. In the Pignic-Gazprom judgment, the General Court annulled the Commission's decision to reject a complaint on the grounds that it failed to inform the complainant about the possible application of the state action defense. In the Spet Pro judgment, the General Court annulled the Commission's decision to reject a complaint and to refer it to the Polish Competition Authority. The Commission, in the Court's view, failed to examine the evidence put forward by the complainant, showing that there was a real risk of a breach of its rights if the complainant was handled by the Polish Competition Authority, having regards to deficiencies in the rule of law in Poland and the alleged lack of independence of the Polish Competition Authority. So in my view, the General Court or the Court of Justice has not pretended to possess the ultimate economic expertise. Overall, the case law remains within the limits of a comprehensive legality review, assessing the completeness and the plausibility of the Commission's assessment. It is the increasing substantive, namely economic complexity of the cases under review, that leads to an increased procedural complexity. As the recent case law demonstrates, the Union courts focus primarily on whether the Commission has taken all relevant aspects into consideration in its analysis and whether the parties to the procedure have had the chance to address these aspects fully before the decision was taken. If a mistake is detected, the courts assess further on a case-by-case basis the quality and nature of the error or omitted aspect and evaluate their consequences on procedural fairness. It has, of course, been argued that such a review could all too easily amount to a mechanical exercise in ticking boxes, and hence the risk that even small mistakes could lead to sweeping annulments. Nevertheless, while the General Court considered the errors in Intel Renvoi and in Qualcomm exclusivity payments to be significant in that regard, Google Android is an illustration of how an error relevance analysis can lead the court to a different conclusion. But even if one concludes that the root cause of the present challenges to competition enforcement cannot be found in a judicial overreach into a second guessing of complex economic assessments, one should not adopt what in French is called a Panglossian view of the present situation. All is not well in the best of worlds. If increasing complexity in the interpretation on a case-by-case basis of very vast, imprecise legal terms lead to increased procedural complexity, legislation, and maybe the review of Regulation 1, presently at hand, might need to fine-tune the tools to deal with that complexity. Otherwise, competition enforcement may, at least in certain situations, face irrelevance. This is of particular importance in relation to the digital economy, where, as the Maire de Montjoie Schweizer report already pointed out in 2019, market boundaries change rapidly, large user bases can be created or leveraged rapidly, and future developments are very hard to predict even on a relatively short horizon. The adoption in the 20th year of the existence of Regulation 1 underscores the adoption of the Digital Markets Act underscores the urgency of the matter. As Schweizer observed, the draft DMA is to be commended for its attempt to shift from the broad competition law standards to a set of rather concrete rules. This approach will facilitate a more robust and speedier protection of competition than could be accomplished on the basis of Article 102. While the DMA is without prejudice to Articles 101 and 102 and corresponding national rules, it aims at complementing the enforcement of competition law. The DMA, together with the traditional competition rules, thus establishes a two-tier approach to ensuring competition on digital markets by allowing for a management of risks for the competitive process on the markets. However, this approach is essentially limited to the regulation of so-called gatekeepers, acknowledging thus the intrinsic risk that they cause to the digital markets characterized by extreme returns to scale, network externalities, and the key role of data. It will be very interesting to see the interplay between the DMA and competition law once the DMA will be applied in practice. And I guess that depending on the DMA's impact, the question may be asked whether there is a need or a scope for such two-tier approach beyond the regulation of gatekeepers. Indeed, the recent BPOS judgment confirms that the same behavior can be subject of both general competition enforcement and more specific regulation without breach of the nebis in idem principle. Following the DMA, further regulation that is inspired by competition rules while being more specific might thus see the day. And this is, by the way, not an entirely new development. Already the telecoms framework enacted almost 20 years ago was in some aspects a similarly tailored instrument. When reflecting on the design of such two-tier approaches for the sake of an efficient and timely enforcement, the balancing of the tension between flexibility and efficiency is of paramount importance. And I come back to the Kremer de Montjoie-Schweitzer report, where they put that flexibility is a particular strength of competition law with its broad, open, and general rules. Yet this strength of competition law, its case specificity, also has a downside in the sense that the determination of the relevant competitive forces in each case is time-consuming and costly, and the corollary of the breadth and flexibility of competition law is that its implementation is typically an elaborate process. Going further, Heinemann asserts that with respect to unilateral behavior, the proper balance between form-based and effects-based elements has not been found yet. So these statements may still invite to revisit the balance between a rules-based and a case-by-case approach, at least when it comes to questions where the expectation that a more economic approach would provide enforcers and judges with one correct assessment has not proven to be consensual. When science does not deliver one holistic and singular truth, or when consequences of a practice change or develop over time, or when different parameters conflict with each other, the balance between different options and interpretations is not a pathology, but a necessity. And it is a necessity that requires a normative answer. And so, in fact, this question is not only relevant for the interaction between general competition enforcement and more specific regulation. Think that somewhat ironically, 20 years into the history of Regulation 1, we may be back to consider the virtues of a well-dosed form-based, or as I prefer it to call, more normative approach. And this might lead to the identification of possible changes in the regulation itself rather than in separate instruments. For example, at this moment, in its essence, the regulation is based on a concept of competition enforcement as a repressive, also by some called quasi-criminal instrument, aimed at the ex post sanctioning of a behavior for its anti-competitive object or effect. In the logic of the Menarini judgment of the European Court of Human Rights, the quasi-criminal character of competition enforcement requires judicial checks and balances corresponding to this character. And this suggests that the more novel and the more complex the alleged infringement appears, the more must be required from an investigation before a quasi-criminal sanction intervenes. Whilst the quasi-criminal side of competition enforcement will undoubtedly remain essential also in the future, the question has therefore been asked, think of the so-called new competition tool, and may be asked again in the future, if the repressive side of the instrument must not be complemented by other tools for the management of risks in uncertain situations. The present interim measures tool may not be sufficient or appear even to be suited in that respect, if only because it is ultimately in its present conception an inherent part of the repressive procedure. Genuine risk management tools, like possibilities to sandbox novel and innovative practices, as an example of participative antitrust as advocated for by Tirol in his keynote speech at DG Comp's 2019 conference, Shaping Competition Policy in the Era of Digitization, so as to gain insights into their possible harmfulness, could go quite some way to prevent the fait accompli. To put it differently, the question of whether there is scope for amendments to Regulation 1 that allow for certain precautionary mechanisms could be put again on the table. That is, for mechanisms that do not sanction or fine undertakings, but that enable more detailed risk assessments before business practices are widely deployed. But of course, this begs very complex questions, as we saw already in part yesterday, because the question is what criteria could or should trigger such mechanisms, whether the substantial and procedural requirements for such mechanisms could be faster and less case-specific than the substantial and procedural requirements for repressive mechanisms, and during what time span. So this is not an easy question. And it is clear that putting this question raises also the question to what extent changes to the present set of rules can be operated through secondary legislation, and to what extent any further substantial change requires a change of the treaties. Some contributions seem to suggest that the legitimacy and coherence of EU competition enforcement limit the scope for the development of secondary competition law. Thomas Jäger, for instance, recently argued for a solid constitutional basis for competition law enforcement in order not to undermine the division of powers, legality, and judicial protection. I do agree that this should be the case for the fundamental objectives of union competition law and their possible modification or extensions, say if one wanted to address also social or environmental considerations through competition law. Conversely, I think that there is a case for an expanded role of secondary legislation under Article 103 of the treaty in defining clear evidential and procedural standards, including tests that are predictable and workable, while allowing for the flexibility needed to adjust to new market developments and economic theories. There is no reason to extend what some call the over-constitutionalization of EU competition law in this respect. In fact, if one wanted to look into treaty revision with respect to competition law, maybe the most salient aspect would be the fact that still today, the legal basis of Article 103 of the treaty is not in line with the ordinary legislative procedure. You know that this is one of the few legal bases where the lawmaking is essentially done by the Council and where the European Parliament only has an advisory role. So in my view, it is worth exploring on how secondary legislation can make broad and vague notions more concrete, that is, establish operational legal tests and workable proxies, as suggested by Ibáñez Colomo, or on how secondary legislation can enact optimally differentiated rules, a term I believe coined by Christiansen and Kerber. That could be the case for novel precautionary mechanisms, as just mentioned, as well as for the traditional quasi-criminal instrument. Given what is at stake, the contribution of the democratically legitimized legislator to the development of competition enforcement should not be overly ruled out from the outset. Let me conclude with a few illustrative, exemplary, and by no means exhaustive suggestions with a view to more detailed rules in an amended regulation, which might contribute to an even more efficient enforcement in the future. Concerning the definition of operational legal tests, workable proxies, or optimally differentiated rules, the following parameters should demand attention. First, standard of proof. Already Kremer, Le Monjoie, and Schweitzer drew attention to the need to rethink both the time frame and the standard of proof with respect to the error framework inspiring competition enforcement. So, the standard of proof is at the core of defining the mission of competition enforcement in a given system by determining its level of risk aversion and its openness to proactively address risks before they materialize. The presumption of innocence requires an exacting standard of proof where competition decisions lead to a fine. Given this fundamental importance, I ask the question whether there is a case for the legislator to define a more specific standard of proof applicable to a given breach of competition law and or even dependent on the market investigated, and whether the standard of proof might differentiate between precautionary and quasi-criminal interventions. One could also look at the lessons to be learned from other regulatory contexts. Let me just point to the REACH regulation. The European Chemicals Agency, the Commission, and the Union courts regularly deal with complex scientific assessments when evaluating the risks of certain chemical substances. Here, what is foreseen is the so-called weight of evidence approach as a principle guiding the assessment when various studies provide different or conflicting conclusions, or where one single study alone is not sufficient to support a certain conclusion. In applying the weight of evidence approach, the regulatory authority weighs the available information according to factors such as the quality of the data, their reliability and their relevance, so that it can then rely on the overall weight of evidence to support its conclusions. And the question is maybe whether such an approach, if adapted to a revised competition law framework, could help to develop more refined tools that address economic complexity in a procedural and methodological safe way. The question is also whether this would prevent the ticking of boxes risk that has been associated with the increased procedural sensitivity of the union courts. Secondly, burden of proof. Correspondingly, is there a case to refine the rules on the burden of proof, including the degree of substantiation required for challenging a plausible theory of harm and the possibility of recourse to refutable presumptions? Thirdly, prominently discussed yesterday afternoon, remedies. Should there be more specific provisions on remedies, in particular regarding situations in which a market is in risk of tipping or has already tipped, or a fait accompli may emerge or has been created? Beyond these issues touching on the boundary between substantive and procedural law, the following, more specifically procedural issues, might also be considered. Fourth, rights of defense. Could it be advisable to translate into the legislation certain standards derived from the case law in relation to the rights of defense? That is, for instance, the standards for detailed minutes of interviews and meetings, or a clearer definition of the situations in which to address modified statement of objections if the scope of the investigation changes during the administrative procedure. Fifth, administrative procedure. In order to make the administrative procedure speedier, would it be conceivable to organize the administrative procedure around two clearly structured rounds of written exchanges, like the judicial procedure? Could such an exchange be followed by an enhanced oral hearing on the merits before the administrative decision is taken? That could, for instance, also include the calling of experts, including by the Commission itself. Could such a solution be enriched by elements from other administrative procedure and regulatory contexts involving complex scientific assessments with a view to making judicial review more informed and thus speedier? And finally, complaints. To give but one example of a possible precision, the already mentioned SPED Pro judgment has underscored the rule of law standard in competition procedures. Concretely, the court applies the two-tier test from the field of judicial cooperation in criminal matters to the administrative treatment of complaints. Should such criteria be codified, both in relation to the complaint procedure by the Commission and the cooperation with national authorities? More generally, should the rights and obligations of complainants obey to clearer definitions, and/or should the margin of discretion of the Commission when dealing with complaints be spelled out more clearly, namely in terms of the standards for the rejection or the non-pursuit of complaints? A number of questions that are on the table. So I conclude. As I said at the beginning of my remarks, these reflections are nothing but food for thought. And of course, none of these ideas conveys a formal or informal position of the General Court. I just wanted to share some of the ideas that more unstructured than structurally have been in my mind when following recent developments in competition enforcement, in the hope that they spark further fruitful exchanges today and in the future. Thank you very much for having me, for your patience and for your attention.
All expectations. I think there's so much to discuss that I wonder who wants to start. So maybe okay, here we are.
Thank you for a very interesting and thought-provoking keynote. And my question ties in what we discussed yesterday, because we talked about interim measures. And today we talk about, well, standard of review at the court. And the interesting thing, well, I consider it interesting with interim measures is that when the Commission hands down interim measures, the undertaking is able to appeal that decision with the Union Court. However, the undertaking can also apply for interim relief with the Union Courts. However, the test in order for the undertaking to relieve itself of the interim measures is this almost the same as the test for the Commission to hand down the interim measures. Do you think that is, well, for example, the undertaking must prove that there is a prima facie fault actually in the interim measures decision, but then you have a decision based on a prima facie infringement, but the undertaking must prove that there is a prima facie fault in the decision, which is already prima facie. So do you consider this, well, the right way to, or the right standard, or must this also maybe be changed?
I have, of course, no ready-made answer to that, but I would point to an aspect of the discussion yesterday. I think we are all to a point puzzled by the fact that there have been so few interim measures in competition cases in the 2 decades of existence of Regulation 1. And there are different explanations that are delivered for that. And one of the recurrent comments is that the standard is too complicated. I am not sure about this. I think that the main problem is probably that the procedure for adopting interim measures is almost as complex as the procedure for adopting a final decision. And that was yesterday put a little bit in evidence also when there was the comparison between the national procedures, say in France, and the procedures at the EU level. Typically, procedures for interim measures are lighter, and that you see at the court. The procedure for interim relief in front of the General Court and in front of the Court of Justice is typically much faster and really centered on the provisional situation that has to be either not kept open or kept open. But that also brings me to my second observation. I'm not sure that, I mean, of course, interim measures are being discussed. It's in the menu that has been mentioned by MaCCI yesterday. But I do not think that interim measures are a kind of magic recipe to solve the issue of speed and length of procedures. For those who are German-trained lawyers, we have seen this in German administrative law that for some time there was quite a tendency that the interim procedures would create the fait accompli that should be avoided in reality through interim measures, and that the main proceedings in the end were no longer the real effective judicial procedure. That has been changed a little bit in German administrative law as far as I have seen over the last 2 years. So the interim measures tool is a specific tool that is foreseen to enable a final decision in right now a repressive ex post sanction system. So it should not be confounded with a more precautionary mechanism that would be applied liberally just to address perceived risks. For that, we need a different normative framework, I should think.
Maybe I continue with a second question. You convinced me with your analysis that we have a double problem of complexity. So we have a combination of substantive complexity with procedural complexity, and we have to find a way to how to handle that, or how to reduce it to a degree that we can comply with what we should comply with, deliver justice in time, and deliver protection of competition in time. And then you made some proposals which I think are quite revolutionary. So one of your first idea was not revolutionary, I said, but I would say, continuing what we started with the DMA. So this what you call the 2-tier approach. But when my concern there would be that this would really lead to a marginalization of competition law. So if you continue with that and go sector by sector, and in any sector where we find that we are not fast enough, we now need a regulation. So we really reduce what we can always fall back to competition law if we find something new, but we enter a kind of a regulatory cycle where we will update regulations year after year, as we have started to do in Germany partly. I don't think that this should be the direction we should go. And then you came with your different proposal, which I find extremely interesting, and I've never thought about before, which is to use Article 103 to specify some of the standards. The problem that I see there, it really is that, and you mentioned it basically, in the Commission could write its own policy. So yeah, the Commission could say, well, we have difficulties enforcing, so we now specify what we think we can do, and the Parliament would not be even part of the process, which is in you talked about the need for checks and balances, and I think here we have a problem. And then you also mentioned a third point, and I wonder, we mentioned it yesterday already, couldn't we find a separate procedure, one where we do not have the criminal law standards, but a different standard? And you then mentioned the new competition tool, or what we talked about yesterday, the market investigations. But we talked about it in your panel. In Germany, we have these two different types of procedures. One where we have criminal law standards, one where we have administrative law standards. I wonder, I don't think we can be very sure of how different the procedural standards would be in EU law for a purely administrative law proceeding, but it wouldn't need to be a new competition tool. It could be Article 101 and 102 without fines. So,
first of all, I think I must make very clear that I don't make proposals. I discuss working hypotheses. So I have, for instance, absolutely no preference between a two-tier approach or changes to Regulation 1, or even continuing if people think it's at the end of the day the most satisfactory situation in the present way. Because of course, as I said at the beginning, and I very much share what Mr. Ibáñez-Colomo said yesterday, complexity cannot be wished away. And we should also not succumb to the desire that complex issues could be resolved in a half year or a year. They cannot, if only because of bureaucratic issues like the handling of confidentiality requirements and so on. But also, I mean, in order to assess complexity, you need evidence, you need time, you need contradictory debate. I'm just seeing that these issues could come up because still, despite all of this, there seems to be insatisfaction that is prominently voiced also from time to time with the speed and the effet utile of competition law as is. So in that sense, I think that if the competition law community wants to avoid the first danger that you mentioned, namely that over time competition law is marginalized, then it must reflect on how to make competition law more workable. And I think that here you are right. It is only partly, at least, I think, the dichotomy criminal or quasi-criminal on the one hand and administrative on the other hand. There can be differences here, and clearly the Menarini sensitivity has a lot to do with fining, with shaming, and all of that. But this does not mean that the Charter of Fundamental Rights does not apply to administrative procedures. That is very obvious. Yet, or hence, I think the other side of the coin is that if complexity means very broad and vague notions, what we call in German unbestimmte Rechtsbegriffe, the issue becomes more difficult. And so that is my interrogation, if whether a certain dose, not an exaggerated dose, it's a well-dosed normative approach, could help in that respect, so that the wheel does not need to be found in every case again. I mean, maybe yes, in the past, presumptions were too easily invoked, but maybe today there is a question whether what the Portuguese call saber de experiência feito, a wisdom derived from experience, is discarded very quickly in order to look again in the specific case, is there something or is there not something? And that, of course, is how criminal enforcement works, but not necessarily risk management. So I think it's an open issue. I don't have the final answer. And to address the final point that you make, I think, of course, 103 is not an empowerment for the Commission. The legislator under 103 is the Council. And the Parliament has an advisory capacity. It's the pre-European Union situation of legislation. But if competition law, this is now a purely off-the-cuff remark looking at political realities, wants to avoid the drive towards the two-tier approach, maybe part of this is to put the legal basis of 103 into line with the ordinary legislative procedure. Because it is, right now, it is a very specific case within the treaties, this legal base, which on the one hand is very important, yet on the other hand, clearly does not conform to what has become the ordinary legislative procedure in the past decades.
When teaching competition law, I always wondered, presenting Regulation 1 of 2003, why is there a rule on the burden of proof? Of course, that's explainable, dealing with 1013. But I think you pointed to instruments which have been long forgotten, and the idea of evaluating Regulation 1 of 2003 was, I think, too much centered on the existing instruments and did they work or not. Looking into into Article 103, I think that there are the options, both for a more normative approach and for the type of rules you mentioned as possible regarding, for instance, what Article 103 calls to define the respective functions of the Commission and the Court of Justice. I mean, how this division of labor is organized could be subject of secondary legislation, as could be in just the preceding section, to define, if need be, and I think there is need, in the various branches of the economy, the scope of the provisions of Articles 101 and 102. I mean, that's what we're thinking about, whether this scope, for instance, in relation to unilateral matters, should be more specific than just the mere wording of Article 102. So there could be, whether this is best placed in a new recast Regulation 1, I mean, no, is a different issue. But I mean, I think not only should we have a more specific procedural framework for the Commission's proceedings, not just those in relation to the undertakings when making searches and the like, but also for subsequent dealing with all these matters. But also, should we think about these more substantial aspects in getting more clear normative rules on these two critical issues? And I think that was extremely helpful in your speech to point to these possibilities. Thank you.
Thank you. And I think you have grasped my intention. Indeed, I mean, as I said, I make no proposal. The question is, if people think there is a need for action, then one has to look at the possibilities for action. Of course, people can conclude, say after the evaluation sometime in 2024, that after all, the situation is not so unsatisfactory overall, and let's continue with adjustment here and there. But if the feeling was that something more is needed, then I think there is an avenue here, and it's of course for others than the judiciary to explore whether it can, should, and to what extent it would be used. That is very difficult. But My feeling is just to sum this up again, that if scientific, technical and economic complexity meets broad and vague legal notions, if the judge does not want to become the second-guessing economist, the refuge, if I may say so, is procedure. And procedure will therefore become deeper, lengthier, more thorough. That is not an offense, I would say. That is a natural conclusion in the division of labor between scientists and jurists. But if it is felt that at some point in time, all of this takes too much time without there being a decision, then you have to make normative choices here. That is at the end of the day, I think, the conclusion to which I come.
Thank you very much for your speech and your remarks. I liked it a lot. Madeleine Kaak from University of Innsbruck. I want to follow up on your last point. If we change the procedures and if we put more effort in getting better procedures, the enforcement will be lengthier. But in the last couple of years, we've seen a big trend towards commitment decisions, towards cartel settlements and mixtures in between. How does this fit in? Doesn't this enforcement trend kind of cut out the judicial review at a very early point? And also when settling cases, either with commitments or cartel settlements, isn't this maybe the wrong trend for complex economic assessments?
I mean, this is a difficult question for a judge because part of the separation of powers is that judges do not create their own cases. That is why we have in German the saying, wo kein Kläger, da kein Richter, or wo keine Klägerin, da keine Richterin. That, I think, should remain like this. I would not like to create the impression that there is a message coming from the judiciary to enforcers and businesses alike to refrain from settling issues that more economically are settled through commitment or other decisions. It's an avenue that is open. The important thing, of course, is that it must not be a coercive avenue. That was also slightly discussed yesterday afternoon. I think in that respect, our EU system offers quite abundant guarantees because it does not necessarily mean that you can no longer ask the court to review something just because there was a settlement or a commitment. And also, of course, here you have the role of complaints. That is also not unimportant at the end of the day. If you look at the Pignic-Gazprom judgment of the General Court, it deals with a situation where the Commission has come to a solution with a party, but the complainant was not satisfied with it. So all of that, I think, is an interesting matter, but I think there is a limit to what a judge can oppose to the willingness of parties to find alternative dispute settlement.
Yeah, thank you for all that thought, all that food for thoughts, and there's really plenty of that. I have a question on our framing of the sanctions as criminal sanctions and the relation to that criminal framing to the object and the standard of proof. So if this is really criminal sanctioning, why can the courts basically restrict themselves to only reviewing the procedure and not basically coming to a conclusion with regard to whether there is a criminal offense or not? And secondly, and relatedly, what is the lowest standard of proof that we could accept for establishing such a sanction? And could it be kind of, a better path and a less radical path, basically, to lower the sanction of the standard of proof maybe in certain areas, maybe to mere preponderance of the evidence, or even lower than that. And ultimately, you know, do we have to frame this as criminal, or could we reframe it as basically providing incentives to corporations, which are not natural persons, to basically act in line with workable competition? And could that ease our dealings with complex economic questions in these cases?
I think in a sense, of course, your remark and question echoes what Professor Schweitzer already mentioned. And this is a complex matter. Let me start, first of all, by saying, of course, the present legal framework, Regulation 1, does not define itself as a criminal enforcement or even a quasi-criminal enforcement framework. It defines itself as an administrative law framework. It is the influence of the European Charter of Human Rights and the EU's Fundamental Rights Charter that has sharpened the sense, if I may say so, for the invasiveness and the sharpness of certain instruments. And that is also reflected, of course, in the treaty and in the regulation itself by the distinction between the general standard of judicial review and the unlimited standard of review concerning the fine. And you may have seen that in that respect, the General Court in recent judgments has gone further than in the past in modifying the fines that were handed down by the Commission on the basis not of finding necessarily a mistake made by the Commission, but simply on the consideration that the court here, in the exercise of an unlimited jurisdiction, could come to another conclusion in its own right than the Commission. But that, of course, is only applicable to fines. When it comes to decisions, of course, then at the end of the day, the court reviews what the Commission has decided. And of course, there are examples of Commission competition decisions where the Commission has deliberately not included a fine. This being said, it also has to be said, as we just said a moment ago, this does not create a fundamental rights-free zone. And the question may be asked whether certain merely administrative measures are not actually more invasive, more intrusive, more difficult for an undertaking than a mere fine. This question has been asked in other contexts when the impression was that some businesses can pay fines rather easily, so that a system of deterrence based on financial sanctions is actually maybe no longer as deterrent as it was initially foreseen. So I don't think there is an easy answer. For me, maybe the question that could be explored, but needs to be explored further, is whether there could be a greater distinction between precautionary risk management measures and really something where a repressive final decision that also comes with the finding of an infringement would be taken. But of course, I mean, if at the end of the day you have to divest your cash cow, is that less intrusive? Is that less invasive than a fine of even a 3-digit million euro price?
But I have one last question. You didn't mention one option, which is a specialized competition court. And there's one puzzle, I don't think it's completely related, but when you look at national courts reviewing decisions by national competition authorities on Article 102 grounds, they apply somewhat different standards, and it seems to me. So it's not all like the path that the European courts are choosing is special to some extent, not only on procedural grounds, I think. I wonder, because if I read the Court of Justice's judgment on Enel, I also think there is some substantive change there, or at least the summary or the restatement of the law on Article 102 is to some extent selective. If they say you normally use the AEC standard and don't mention that it's not, it doesn't make sense to apply it to platforms where the economies of scale and scope are so immense that wouldn't make sense. And then they mention the no economic sense standard, but don't mention the proportionality principle. So in a way, I also see that there is some sort of interpretation of Article 1 or 2 which has changed on the substantive side. And there seem to be swings in how you interpret the law, and there could be a correction of the swings in a way. What we see currently at the European level is that in a way, a problem of timing. The thinking of the Commission has changed, but the thinking of the judges has changed in a different time frame, so to speak. And so maybe a specialized competition court would help to get both ways of thinking more into tune.
I mean, I have gone into some detail on judicial review standard and also the division of labor under the treaty between the Commission and the courts. Precisely, you are right. The EU system is special, but that is due to the specific setup chosen by the treaties. There are different systems. I mean, when one travels through the worldwide competition community, there is the age-old debate whether the European model, broadly understood, or the US model is superior in terms of outcomes, in terms of the respect of the rule of law, you name it. And even within Europe, I mean, there are differences. If I look at the UK system, the Competition Appeals Tribunal has a different possibility, if I may say, of doing a full merits review in all detail. That is just not at this point in time the legal architecture. And I think changing Regulation 1 is a cumbersome task. Maybe at some point in time, changing Article 103 will be envisaged, but a fully fledged change of the judicial architecture that is foreseen by the treaty, that is a Herculean task, if I may say so. And in reality, also, even at a lower level, the trend has gone in a different direction, I simply note, because first, the Court of First Instance was established. Then the so-called Civil Service Tribunal was established. And at the time, the expectation was that over time, more other specialized courts might emerge. But the contrary has happened. The General Court was increased and the Civil Service Court was reabsorbed into the General Court. And I think that this whole discussion about specialization, of course, it will never go away because there is a high entry fee to be paid into competition law. And if you get a complex competition case as a generalist judge or as a generalist director general, you have to invest enormously into this. At the same point in time, for instance, why has the General Court been doubled and not just been increased by 1/3 or by 2/3? Ultimately, because all the legal cultures of all the now 27 member states shall be represented in that court. And so one argument against an over-specialization is also that not always a limited number of judges from a limited number of legal cultures would hear the very complex cases, but that there should be this plurality and diversity of insights so as to also reduce the risk of bias coming from certain preconceptions and pre-understandings. So it is a discussion that will not go away, but my impression is right now that there is a big sensitivity also in the courts to make sure that things are looked at really from the point of view of all the 27 legal cultures. Since the membership of the General Court was doubled, a lot more cases are heard by what we call the formation élargie, the enlarged formation, 5 judges, the full chamber instead of only 3. And even the Court of Justice is hearing more cases these days in its enlarged formations, including the Grand Chamber, than may have been the case in the past. And all of that has to do, of course, again, also with the fact that complexity demands also plurality and diversity in the assessment. So it's not a clear-cut black and white issue. As far as we are concerned in the court, I mentioned that, of course, at least initially in the history of Regulation 1, the court system was clearly one of the factors of the lengthiness of procedures and the conclusion. I think that has, at least for the time being, improved. And of course, we are eagerly awaiting to see how quickly DMA cases may come to the courts and how quickly the courts will be able to deal with them. That is going to be the next litmus test to see whether the division of labor and also judicial review is working. And one final point, of course, the jurisprudence changes over time or develops over time. I tried to show that, in my view, it is not such a big question of a different degree of judicial review. I think it was an economist who said that when the facts change, I change my mind. And I think that obviously has to apply also to lawyers. If you get different facts, if you get new evidence, if you get conflicting evidence, then you have to look at issues afresh, and more so if the legal notions you deal with are broad and vague and are not normatively predetermined to a great degree of detail.
Thanks a lot for a great talk.